Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. Yesterday I noticed a post on LinkedIn from another immigration attorney, and it was only half right. So today I wanted to discuss the immigration attorney tier system so that you can make an informed decision when hiring an immigration attorney. I'm not here to publicly shame anyone, so I'm going to redact or hide the other immigration attorney's information. So before we go over the LinkedIn post, let me cover the 3 tiers of immigration attorneys. In Tier 1, these attorneys are at the lowest level of immigration attorneys. These are attorneys that are fairly new to immigration, and these attorneys generally handle many different areas of law. Since they handle so many areas of law, they do not focus on immigration and will generally mess up the immigration cases that they do handle. You can easily tell who is a Tier 1 immigration attorney because if you ask them simple questions such as, what does USCIS stand for? Or what are the particular forms required for a particular case? They won't know what the answer is on the top of their heads. Next we have Tier 2 attorneys. These are mid-level immigration attorneys. These attorneys have some experience with immigration and will likely only handle immigration cases. Unfortunately, these Tier 2 attorneys only know about immigration based on what they read in books or what is publicly available on the government's website. Later on, when I show you the LinkedIn post, these were made by Tier 2 immigration attorneys. You'll see why an immigration attorney that bases their advice only on what they read or what is publicly available on the government's website is only half correct most of the time. And finally, there are Tier 3 attorneys. These attorneys have years of experience and will usually handle complex immigration cases. These attorneys will have a website that advertises that they handle immigration cases, have an online reputation and ratings, and will generally handle immigration and family law cases. And it's because these 2 areas of laws are closely related. Tier 3 attorneys have a greater understanding of immigration law because they have likely handled thousands of cases and know that immigration law is discretionary and the information found only in immigration books and what's on the government's website is incomplete. Now let me show you the LinkedIn post that popped into my feed yesterday. Alright, so let's first look at this post from LinkedIn. Alright, so if you look at this post, this person just posted 15 hours ago, and they posted regarding the I-693 medical exam, which is required for the I-485 final stage of the green card application. So he posts something that you can tell this is a Tier 2 attorney because what he posted is not incorrect, but I'll explain why it's not. It's only a half truth and it's not what a Tier 3 or a more experienced immigration attorney would advise someone. So it says, first of all, the I-693 is not required to be submitted with the I-485 filing. You will need it for the I-485 approval, but it's absolutely not required for the initial filing. It might be a good idea to submit it up front, but it's not required, even though USCIS seems to be bullying everyone about the I-693 results right now. So I'm really not sure what he's talking about bullying. What he's referring to is that if you go to the government's website, uscis.gov, and let me see if I can pull it up here. Alright, so if you pull up the form I-485 application 2, register or adjust status, you'll see that there's an alert at the very top. It states that please prevent unnecessary delays by submitting the I-693 with your I-485 application. So as you see here, the government is telling you that you should submit the form, the medical exam, with your I-485 application. But I don't consider this bullying, so I really don't like it when attorneys, they try to make out the government to be very, very bad in situations where they're not. They're just informing people that they should provide it. And let me explain why this post is kind of dangerous and it's not 100% accurate. So at our office, we 100% recommend that you file the medical exam with your green card application. If you are a subscriber to our channel, you'll note that we met with immigration at a immigration stakeholders meeting a few months ago, and they explained that if you submit the medical exam with your green card application, there is a 50% chance that they're not going to require an in-person interview. And if you don't, there's going to be a 100% chance that they're going to require an in-person interview for your green card. So if you're reading this post by this attorney and you don't submit the medical exam just because you want to save a few $100s, you're going to end up wasting money on hiring an attorney to be there at your green card interview because you didn't want to get the medical exam. Another issue with not submitting the medical exam is that you're going to receive a letter, and it's going to tell you that it's going to say I-693 deficiency notice, and it's going to tell you that, as a reminder, you did not submit the medical exam with your I-485 application, and you will require it at a later time. But I will tell you, a lot of people that get that deficiency notice, they scramble, they get nervous, and then they end up getting the medical exam and they send it to immigration without a formal request. The problem with this is that if the government does not request your medical exam and they just notify you that your I-485 is deficient because it lacks the medical exam, if you submit the medical exam without them formally requesting it in a request for evidence or at the time of the immigration interview, most likely if you submit it, they're going to misplace it. So a lot of people, what they'll do is they'll see that I-693 deficiency notice, they'll panic, they'll go get a medical exam, they'll submit it to immigration, and by the time of their immigration interview, immigration will tell them that they misplaced it or they never received it. So again, just a warning, if you see posts from other attorneys telling you that it's not required to be submitted with your green card application, just take my advice and the advice from immigration officials that if you do not submit it, there's going to be 100% likelihood that you will have an immigration interview for your green card. Additionally, if you submit the medical exam outside of receiving a request for evidence or at the time of your interview, there is a good chance that it's going to be misplaced and lost, and you're going to have to do another one and repay an immigration physician to get a whole brand new medical exam. So that's one example of a tier 2 post from an attorney. The next one that I noticed just by pulling up this one, I noticed another attorney post something here. So let's go ahead and look at her post. So here's her post on LinkedIn again. And it says that she's been an attorney at this office for over a year. And it says the process for obtaining a K-1 non-immigrant visa can be divided into 3 main branches. And she writes this whole article that she posts on her website. And let's just take a look at what she posted. And I'm going over this to show you that tier 2 immigration attorneys, they really don't know a lot. So let's go over the 3 steps that she describes for a K-1 visa. The first step that she describes is filing the form I-129F, which is a petition for the alien fiancé. So in this, she describes what's required. She says the evidence that the couple had an in-person meeting, evidence that the couple intends to marry, bona fide marriage, and evidence that the previous marriage has been terminated. So what she is missing here is just the biographical documents. For example, the petitioner has to prove that they are a U.S. citizen. So this is very important because permanent residents or green card holders cannot file a fiancé petition. So this is why the petitioner's biographical documents are very important. So they can show things like a copy of their U.S. or United States birth certificate, they can show their U.S. naturalization certificate, or they can show their unexpired U.S. passport. This right here is also missing proof of the beneficiaries' biographical documents like their birth certificate, English translations, prior marriage certificates, passports if they had it, prior US visas. Also, what this list is missing is criminal records. So if any of the parties have a criminal history, they need to provide a certified copy of their police, arrest, and court records. So those are just two things on the top of my head that they're missing here. So just be careful when you're following advice from someone that maybe is a tier 1 or tier 2 attorney that doesn't really have real experience filing fiancé petitions. The next thing that I noticed is that they're stating that the next step is to provide documents to the National Visa Center. And they're telling you what that you need to provide. Alright, and so here you see, here it says evidence that the previous marriages have been terminated and good faith relationship with the US petitioner. The problem is that all of this right here is required here in the first initial step in the filing of the I-129F petition. So if you don't submit that with your initial I-129F petition, most likely it's going to get denied, or you'll receive a request for evidence asking for that information. So here at the DS-260 stage, honestly, you shouldn't submit good faith relationship documents because it's not required here. What is required is all of this, and what they're missing here is that there are additional financial documents that you have to submit with the Form I-134, which is the affidavit of support, such as the petitioner's most recent W-2s or 1099s, their most recent IRS tax returns or tax transcripts, and their most recent pay statements or their employment verification letter. So you can see here that they're missing things here on this list. The next thing that they are talking about is applying for a green card upon entering the United States. They totally missed out on the consular interview. There is an interview to obtain a K-1 visa, and if you follow this person's 3-step method, you're totally missing the step here where a visa interview is required and what to expect during that visa interview, because it's very important and they're missing it here. But an immigration physical is required, and also an immigration interview at the local consulate. And then the 4th step is correct, which is you have to apply for the green card once that K-1 visa holder is inside the US. Alright, and what they messed up on here is that they're stating that when you file the I-485, you have to submit the Form I-693, the affidavit of support, the I-94 admissions departure record. What they're missing is one, a copy of the US visa. That's very important. The second thing they're missing is a copy of the marriage certificate. And the next thing that they got wrong is that the Form I-693 is not required. If a person came over as a K-1 visa holder, they already did the medical exam, so the medical exam is not required for the I-485. So this is just a good example of why you should not use a Tier 1 or Tier 2 immigration attorney, and it's because they are giving you either the wrong advice or just half-truths. So again, thank you for watching Winning Law. I'm attorney David Nguyen, and we hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David.